Hello, hello.
Yes. Sir, I have to mention a bail application for listing or withdrawal lordship tomorrow.
Withdrawal.
Withdrawal lordship.
May I please, your lordship? I beg to mention for listing of anticipatory bail, lordship. It is supposed to list it tomorrow, today, lordship, but not listed. Kindly on Monday, lordship.
All right. Monday.
Tomorrow, lordship.
You said Monday.
Kindly on tomorrow.
Well, have it on Monday. It is received. I remember.
No,
It's
lordship.
not
Listing.
listed.
For listing.
Yes, sir.
It was earlier directed to be listed today.
Today, lordship, but not listed. I was mentioned yesterday, lord.
You mentioned yesterday.
Yes, lordship, but not listed, lord.
Okay.
Motion. Motion matter, lord.
All right, tomorrow.
Obliged.
May period. I have to mention for item number 26.
Yes.
So kindly maybe my note to come on Monday matter. Please come.
Item number 26. We
Monday.
have got it on
Okay,
this
fine.
matter of Monday.
Monday matter. Monday. Okay.
Meet please, your lordship. Lordship, I beg to mention item number 18.
Wednesday. Wednesday is holiday.
Monday. Monday.
My lord, item number 18 of the daily list, lordship. Lordship, this matter may be adjourned for the day, lordship, with the consent from the other side.
NCB. Yes.
Lordship, it may come after 2 weeks.
For 2 weeks.
Obliged, lordship.
May I please, lordship? Lordship, with the consent of the other side, lordship, I beg to mention item number 36, lordship. Angus council is on some difficulties, lordship.
3-6.
Yes, lordship. Can it be fixed on Monday, lordship?
36.
Oh, 30.
High criminal. Monday.
Obliged, lordship.
Item number 5. I may be allowed to
Withdraw. You are Mr.
D.
The prayer of
Hi.
the T.
Hi. One. One.
Yes.
Two instructions.
Any instructions?
My lord, after some time.
I can.
None.
Oh, put a CP.
My lord. That's rejected on 42. My lord. 12 matter.
May please, your lordship. 483 application, lordship. Original FIR page number, lordship, 18, lordship. May I read this?
Yes.
সন্মানপূৰ্বক মিনি নিবেদন এই যে আজি 21/10/2025 তাৰিখে পুৱা 12:30 মান বজাত গাঁৱৰে নিবাসী ওপৰ উল্লেখিত পদকীয়াকণে মোৰ ঘৰৰ ভিতৰলৈ সোমাই আহি কোনো মাত নিদিয়াকৈ বলক নকৰাকৈ সোমাই
12, 11.
খাই ল'ব লৈছে।
May I please, your lordship. 483 petition. Case is registered under section 118 clause 2 109 FIR is page number 14, my lord. I'm reading. সন্মানপূৰ্বক বিনীত নিবেদন এই যে দিনৰ 1 মান বজাত মোৰ স্বামী সাজিদ আলীয়ে 1 নং পদকীয়াজনৰ লগত তেওঁৰ ঘৰত গৈ খেতি মাটিৰ বিষয় লৈ সোধ-পোছ কৰি থাকোঁতে আছামীজনে চোকাস্ত্ৰ দি মোৰ স্বামীক পেটত মাৰি হত্যাৰ চেষ্টা চলায়। মহোদয়, মোৰ স্বামী আঘাতপ্ৰাপ্ত হৈ মাটিত বাগৰি পৰাত স্থানীয় লোকে চিঞৰ বাখৰ কৰাত আমি ঘটনাস্থলীত গৈ বাকী আছামীক লাঠি আদি লৈ থকা প্ৰত্যক্ষ কৰোঁ। My lord, this is charge-sheeted case, my lord.
Charge is submitted.
That's it.
Charge is submitted.
Charge sheet is submitted, my lord.
Actually, call for scan copy here.
TW1 has been
TW1 also accepted. TW1 also examined. Actually, call for trial for that.
Here. Okay.
Seventeen.
13, my lord. 17 of money.
Zero, particular case. Borrow, specific, 13 months.
Happy lordship. Let me take an off for some time. In your opinion. Blush. May it please, my lord. My lord, I duly apologize, my lord. Item 2, my lord, I am the conducting counsel. I just missed it by a stroke of bad luck, my lord. Can it be taken up, my lord? I have an interim prayer, my lord. Actually, one of the applicants is a disabled person, my lord. If I may just demonstrate for just 2 minutes of this offer, I'll just take 2 minutes of this offer. If it pleases, my lord. Item 2, my lord. Kindly, my lord. My lord, may kindly have page 13, my lord. FIR, my. That on 5/10/25 at around 6 p.m., I was coming from other people's house towards my house when the accused found me alone in a deserted place and gagged my mouth and took me to a nearby bill and forcibly raped me.
My lord, FIR is at page number 10. There is no any specific allegation against me, my lord. My lord, kindly have a short date, my lord, as because he is suffering from,
Yes, when?
my lord, high illness.
My lord,
Fine, very clear. Huh?
seven. Seven.
Item 7.
Highly obliged.
May I please, your lordship? Lordship, because I will lordship. Report as call for.
Report call for. Satan down for who?
Any instruction?
My report was call for not received. Fix Monday.
The report as called for has not been received. Is the matter again not heard?
Oblate.
No. What if report was called? Item number 8, no? 8. Report received, my lord.
Yes, what is that?
It's secret.
Yes, I heard.
My lord.
Okay.
Okay. Okay. Lordship, police came on 9th
As
to
per
search the-
report submitted by the inspector, by the OC, Mati PS. No case has been registered against the petitioner, Ritik Raj Chaudhary, till date. This application is in fact
Dispose. Yes.
keep the report on in the report.
9.
May I please, the Lordship? Lordship, allegation is under section 108 of BNS. Lordship will find the translated copy of the FIR at page 12, Lordship.
Yes.
Lordship, the basic allegation in this case is that, Lordship, the deceased has committed suicide, and it is due to the mental and physical torture caused by the petitioner, Lordship. The allegation is that. But what has happened in this case is that, Lordship, the maternal aunt of the deceased introduced the petitioner to the deceased, Lordship, for the purpose of marriage. And thereafter, marriage talks were going on between the families of both the petitioner and the deceased person, Lordship. And later on, the family of the deceased
No
person.
direct act is attributed to him. They only think that because of
My
Lordship, but
before
actually-
2 days in the FIR itself, my lordship may call for CD, my lord, if it is required, my lord, CD. Here, my lord,
But there is a significant point to be noted here, Lordship, that the family of the deceased, Lordship, they had stopped the education of the deceased person, Lordship, for which she was in
before
mental
2
pressure,
days, my lord,
Lordship.
she was my lord, physically and mentally tortured.
all for the CD having regard to the next set of negative
For that, my
pertaining
lord,
to abatement of suicide by the victim and having regard to the fact that overt act has been attributed to the petitioner. Provided that injury
20, my lord, 20.
Much obliged.
attempt and we follow up after some time, otherwise again somebody will come and say. 11.
May I please?
Page, FIR page number lordship 8 lordship. And the vernacular page number 10 lordship. The FIR is lost on 2nd of August 2025 and the incident occurred on 25 April 2025. About more than 3 months later, the FIR has been lost. I'm reading the vernacular part. সম্মানপূর্বক বিনীত নিবেদন এই যে যোৱা 1 বছৰ ধৰি ওপৰত উল্লেখিত 1 নং আসামীজনে তাৰ ল'ৰাৰ লগত মোৰ ছোৱালী মমতাজ বেগমৰ বিয়াৰ প্ৰস্তাৱ দিয়াত উক্ত প্ৰস্তাৱটো মই অস্বীকাৰ কৰি মই মোৰ ছোৱালীক বেলেগ ঠাইত বিয়া দিয়া বুলি 1 নং আসামীজনে শুনা পাই উক্ত আখেজক কেন্দ্ৰ কৰি যোৱা ইংৰাজী 25/4/2000
May I please, your lordship? Previous bail application, madam. FIR is on page 7, madam. Vernacular is on page 12, madam. And what happened, madam? The accused and the victim went for watching Meena Bazar, madam. And on after 2-3 hours, the parents of the accused handed over the victim to her parents, madam. That is the case, madam. And FIR was lodged after 4 days of alleging offense, madam.
My lord, she was 13 years, 5 months at that time. And she was taken on 18/9, but recovered on 19/9, my lord. Next day, my
On that day, my lord, as per FIR, 3
3 a.m.
3 night, my lord,
night.
at night.
7 hours.
7 hours.
But get the it like the it have taken up the my daughter of the not 59, 28, and 18. Third, first affected parents the excuse and it yeah, the same night. Same. Just did
Hello, how much?
My lord,
David did.
My lord,
I may be protected, my lord.
In case
Same.
you have not heard,
My lord,
my lord. 17.
am I not audible? Yes, next.
obliged, my lord.
May I please, Your Lord. By this application filed under section 482 of the BNSS, my law, the petitioner is praying for 3 years bail in connection with Bodhapur PS case number 175 of 2025 registered for various offences, my lord. Sir, I will take your lordship to the FIR, my lord. We should lordship this translated copy of the FIR at page 15, my lord. He is not on the petitioner is not the his name is not mentioned in the FIR, my lord. His father, name of the father, his father and youngest brother are shown in the as accused, my lord, accused number 10 and 11, my lord. And only, but why I am apprehending, my lord, for arrest, my lord, that I have stated in paragraph number 7, my lord. At page 6. The petitioner begs to state that he is a completely innocent and has no involvement whatsoever in the alleged incident mentioned in the FIR. Over and above, we now hear nowhere in the FIR is attributed about the involvement of the petitioner, but as his younger brother, Mission Ghosh, had already been arrested on 5/10/2025, and as the police is also looking after his father, namely Mohit Lal Ghosh, for his arrest in connection with the so-and-so. The petitioner is reasonably apprehending of his arrest, being a member of the same family, my lord. On the day of the date of the occurrence, my lord, the petitioner was at Udarban, my lord, far away from the place of occurrence, my lord, that I have stated on paragraph number 9, my lord, page 7, my lord. All along here, he is staying in Udarban, my lord, carrying on his hotel business, my lord. Paragraph 9, the petitioner most respectfully begs to state that he is earning his livelihood by carrying on hotel business in Udarban, Silchar, far away from the place of occurrence. On the date of the occurrence, he was looking after his hotel business, and consequently, he is nowhere involved with the untoward incident which took place on 2/10/2025, my lord. At this time, my lord, let a CD may be called for, my lord. I may be a Indian interim, my lord. I may be protested, my lord, from my arrest, my lord.
My lord, here offenses are, my lord, 109, 103 is also here, my lord. But we call for CD at this stage, my lord. After period of the CD, my lord, we consider it. Serious in nature.
No, that I admit, my lord, but actually, what about my involvement, my lord? Nowhere in the affair, nowhere my name has been mentioned, my lord. I was staying in Durban, my lord, far away from the place of occurrence, but that I had stated in my petition also, my lord.
He has very specifically named the people
My lord.
involved, but he is not there.
No, no,
But his apprehension is.
no, my father and my younger brother are mentioned, my lord. That I have said, my lord. And the police actually could not arrest my father, my lord. They have pursuing to arrest me, the prisoner, my lord.
Into the house of the informant. 25 attack the not named in the FIR of the separate with the name there. Yeah, but his other name. Right. Above.
Obliged to lord.
24th, 24 11.
May I please, Lord? For a TT obligation, Lord, the report was called for whether any FIR has been left or registered. 14, huh?
40.
40.
My lord, report received, my lord.
Yes.
No case.
No effort.
So, sir, if there is a no any FIR, Lordship, why the police of the Bhavanipar are visit the house of the petitioner and inform the his direct his family member Gowra to approach.
Item number. Which was that item number that report if no case?
My lord.
Previous today.
My
Another item. Item 8. Item 8. Report.
So there,
Name is
Item
Lordship, kindly direct the police, Lordship, the petition shall not be subject to undue harassment.
file a repetition.
my lord.
Item 6.
My lord, with all respect, my lord, a lady before your lordships and offences are possibly bailable, my lord, out of all offences. My lord, lordship would kindly have a look at the FIR. My lord, the background is this, my lord, there's a long property dispute between the parties, my lord. The tenant has alleged that it is a case of arson, my lord. And thereafter the FIR, my lord, it occurs at page 20, my lord. All allegations are against the male members, my lord, page 20. If I third line, my lord, was deliberately got burned down into ashes with a criminal intention and conspiracy by the landlord, owner of the said room, namely Alfaz. My lord, thereafter, my lord, son of, along with his uncle, Qurban Ali, and his son, Muhammad Arman Hussein. Thereafter, it goes on and on, my lord. If I read in totality, my lord, even thereafter, my lord, fifth line from this paragraph, these all three persons had threatened and criminally intimidated him by saying that we better know, lordship may have found, my lord, how to make vacate our said place, and thereafter left his chamber. Accordingly, today, taking advantage of a Diwali festival, all these three persons has willfully, three persons specifically named male, my lord, with a criminal conspiracy had put on fire our said tenanted shop, goes on and on, my lord. Thereafter, my lord, leaving aside 2 lights. At morning hours on the same day at around 11 a.m., when we went to take physical subsequent occurrence, my lord, not the arson part, my lord, possession of our said shop, room, garage, then the said owner's mother, sister, wife, and another lady named Jamila, আমার নাম তো কোনটো? Jamila Khatun, Nisima Khatun, I am Honti Khatun, my lord. Honti Khatun, thereafter, my lord, Sri Khatun, so and so, also few others with a criminal intention and conspiracy by being wrongfully restrained. That section has been attributed, my lord. Wrongfully restraining me and my garage 7 staff members from entering into our said burned down garage for its repair and taking physical position. Another, my lord, that is also available, leaving aside 5-6 lines. I and my garage staff had been to open our said garage. The above said 5 landladies again started hue and cry and forcibly restrained us with a criminal conspiracy and evil design from entering into the, my lord, goes on and on, my lord. Arson par is alleged against family male members, my lord, and regarding the lady, that, with all respect, my lord, 126(2) bailable, my lord, and those sections are attributed, my lord. One is, my lord, with all respect, my lord, wrongful restraint, that is 351(2), 126(2), and thereafter 351(2), criminal intimidation, earlier 506. The lady has been arrested, and even, my lord, there is statutory violations are there, apparent, my lord, page 48, no signature of the recipient, my lord, page 44. And she is there in custody, my lord. Page 44, my lord.
Since when?
Since, my lord, with all respect, my lord, 2410, because she argued with police, my lord, only that is the reason. 48 is apparent, my lord, not received, my lord, that we have annexed, that kindly have a look, my lord, page 44. Arrest memo is arrest memo, my lord. Here no signature, and thereafter the 48 notice, my lord. Page 47, apparent, my lord, no signature. Page 47.
Yes, PP, specific allegations against the petitioners are bailable.
My lord. But here, my lord, in the last part of the para
Yes, sir.
21, my lord, last part of it. While a video later on after a videography of the state illegal activity of the state 5 lady members was also done and captured of the state incident by the local police, local people standing at the site of the incident. From the state willfully illegal act of the state 5 lady members of the landlord's family, it can be said that they all are also involved in criminal conspiracy to burn down our state shop and subsequently restrain us
The
from
criminal
entering.
conspiracy has been videographed.
Well, other some of the person, my lord, who are standing by the side.
My lord,
Not,
this,
not my lord, only thereafter, my lord. Done the captured the state incident and local people, my lord. That is illegal activities, my lord.
their activities came subsequent to the burning down, if the burning
Yes.
down is true, my lord. And that criminal conspiracy, if photographed, my lord, that would be regarding altercation, regarding their non-entry, my lord. With all respect, my lord, not a criminal conspiracy cannot be photographed. Regarding burning down, my lord, burning down is a prior incident, and subsequent to burning down, that is our case,
And
my lord. A
subsequently,
lady, my
my
lord.
lord, subsequently restrain us from entering into our
Meeting
state
of
garage
minds
from-
cannot be, my lord, videographed, my lord, with all respect, my lord. And altercation was videographed, my
Lord,
lord.
call for city at this stage, my lord.
Unnecessary, a lady would be there, my lord. And kindly have a look at 48, my lord. Page 47, my lord. She was taken to the police station for interrogation, but she argued, and that is why all the ladies were let off. My lord, she was kept, and kindly have a look, my lord, page 47. They cannot cure it. Addressed to the husband.
What about the other ladies mentioned here?
They were, my lord, they were also brought. They kept mum, my lord, they were let off. That is why that 48 notice, kindly see, the dichotomy is apparent, my lord. Page 47, 4, signature of informant, my lord, addressed to husband. Husband is absconding because in the arson case, in this case, arson part of it, my lord, his name is there. Alphaz Hussain. Lordship may have on page 47, my lord. Alphaz Hussain. And kindly see signature of informed person mobile number nil. Down below serial number 4, my lord. A lady, my lord, she cannot do anything. But arson part, she is not at all there. And this bailable sections of law are attributed, my lord, regarding criminal intimidation. Criminal intimidation, my lord, front page 351(2). That is why, because 351(2) cannot be against the male persons after burning down their NMA, my lord. How come 351(2) could be attributed to them? It can be attributed only to the lady members. That is criminal intimidation 351(2) bailable against this lady along with other ladies, my lord. And thereafter, my lord, with all respect, my lord, 126(2), my lord. With all respect, my lord, wrongful restraint, my lord. And they stopped, my lord, entrance of 7 garage members into that, my lord, vacant plot of land, my lord, after it got burned down, my lord. Nothing to do with arson, my lord.
Which are the sections involved now? 126(2).
120, my lord, 351(2), criminal, my lord, with all respect, my lord, wrongful restraint. And my lord, 126(2), my lord. 126(2) is wrongful restraint. They restrain 7 members of the, my lord, 7 male members, garage staff, my lord, from entering the plot of land after the house garage being burned down, my lord.
This is non-bailable free.
My lord, arson is 326G, my lord. Earlier 436, my lord.
Rest are all bailable.
Rest all are available, my lord. And this section is attributed to the male members. Male members could not be there for criminal intimidation. They ran away, my lord, if they would have burned down the house, my lord, fearing arrest, my lord. Apparent, my lord.
Sorted. The ticket that's reflected in the FIR. Not that. Not 20, 10, 25. Around 10, 10. The subordinate shop was categorically found down by the accused towards name therein. And of the subsequent dates with the informant site again went take possession of their shop group. The female members of the accused family, including the present petitioner, wrong to be restrained. Prevented them during their part of from the subsequent date was 25 when the when the garage and the place it is again starting at starting for the street automatically taking that submitted the petitioner statement to the treaty. It involves the allegation contained in the first part of the FIR, that is option of arson where free space is male or female mentioned as far as the against the present of the that is under 6.26 bracket 351 3 again further also the 5 ladies named in that affair that also the petition that's also other 5 ladies that are keep despite that leggage being the same again also 5 ladies.
My submission
fact that
objection and subjection to the
prayer for failure to pay. Right. Tell us that it the it the
CGM Tezpur, my lord. Oh, sorry, my lord. CGM Sunitpur at Tezpur.
cooperate with that. Take it.
Highly obliged, my lord. Obliged. Obliged, my lord.
19, well hearing.
It may be taken up for some time, Your Lordship. For some time, Your Lordship, it may be.
We receive the case that
In this case, your lordship, case diary was called for.
yes,
Petition-
received
Petitioner is in custody for the last around 50 days in custody, lordship. Initially, lordship, case
50.
was registered
52 days.
around 52 days.
What
There
is
is a
the
love affair between the uh, petitioner and the victim. Then allegation is that the mother lost the affair, mother of the victim, that he circulated some photographs, and that is how the affair came to be lost. And there was no allegation of rape or any commission of any other
is this?
offense from a plain reading of the affair. Later,
item? Item 20. Indrarup Chaudhary.
Indrarup Chaudhary.
What is all
Let-
this
Later in a
commission certification? Where is the FIR?
yes, lordship will find the affair at page 15.
That is what happens when you connect the FIR at the end. Court gets confused at looking at the previous document.
Annexure 3 is there.
So what is the role of the petition? FIR is different.
No, FIR is not different, my lord. In FIR, my lord, his name has been mentioned as, my lord, process one.
Rohan Chaudhary.
Rahul Chaudhary, my lord.
Rohan. Page 15.
Rohan Chaudhary, my lord.
Yes.
Rohan Chaudhary is that person.
Same person.
Same part. In the forwarding report at page
He is also
21, his
known as
actual
Rohan.
name is shown.
What has been circulated?
Circulated, my lord, initially, my lord, he proposed her, my lord. Thereafter, my lord, he asked her some nude photographs. Then, my lord, believing that, my lord, he will marry
the particular Mary her, my lord, she shared her proposal. Then she was taken to a strange house, my lord, where my lord, she was forced to consume alcohol, my lord, then he committed the offense. Thereafter, my lord, he circulated, my lord, when the mother, the guard, victim guard, she came to know
Committed
that.
the offense means you are taking a photograph or something else.
No, 69 is also there, my lord, huh? Section 69.
These are all afterthought, Lordship. FIR,
So,
had it,
183 statement, my lord, she has implicated.
had it been a commission of rape, Lordship, all these things would have come up naturally in the FIR. FIR, the complainant is completely silent as regards the commission of this afterthought allegation is the petitioner.
It is not necessary to write everything, my lord, in the FIR.
What
This
is
is
the,
not-
what was the 183?
Yes, my lord.
It is not necessary, but an allegation of rape not being mentioned in the FIR is a serious thing, my lord. Already 52 days in custody.
There, any case, whatever be the actual act committed, you are a vile person. So entering into a relationship,
Yes.
trust, taking photographs and circulating. It's a bit-
There is admittedly a relationship between the two.
At the
Lordship,
same time,
and
my lord, this Paul was also having another relationship with another guard.
only on the
They're all right, but I mean, separate issue, but
52 days in custody.
nothing wrong with having a relationship, but then these kind of activities, but that
Only due to refusal of marriage, Lordship, this FIR came to be filed. And this serious allegation regarding
but
commission
there
of
must be material about circulation of the videos. They're in the city.
When the my lord, also I am not relying, my lord, the accused himself, my lord, he has admitted, my lord. He circulated to his friend.
Has anything been seized? The circulated materials?
No, no, that part of case to be, my lord. That part of the investigation is sensitive.
circulated yeah. That has been done by the after the incident. When the guard has reported the incident to his parents, to the parents of the accused person. Thereafter, his action. Where is the material regarding the circulation? That is he himself stated, the statement of the accused person. What is the 182 statement of the victim has stated? He has admitted his mobile has been seized. Okay, we'll see.
Already 52 days in custody, Lordship.
Yes, we'll consider that.
Okay.
My lord, an application for regular bail. The 81 days passed behind the bar. My lord.
What is the allegation? Any instruction regarding CS?
No, Lordship, we have to keep it.
My lord, 81 days passed. Will forward.
It would like to know what is the case.
My lord, FIR is page number 9 to 13, my lord. May I read the FIR, my lord? মহা বিনীত নিবেদন এই যে মই শ্ৰী সঞ্জয় শৰ্মা ঠিকনা জুতিয়া শান্তি প্লাজা জুতিয়া থানা দিছপুৰ মহোদয় জনাও যে যোৱাকালি ইংৰাজী 8/8/2025 তাৰিখে ৰাতি প্ৰায় 2মান বজাত মোৰ দোকান MS কামাখ্যা ইলেক্ট্ৰিকেলছ এণ্ড কো খনৰ কোনোবা অচিনাকি লোকে দোকানখনৰ ছাটাৰ লগোৱা তলা কাটি প্ৰায় 35 লাখৰ ইলেক্ট্ৰিকেল সামগ্ৰী চুৰি কৰি নিয়ে আৰু ৰাতিপুৱা প্ৰায় 5মান বজাত দোকানখনৰ
How have the present accused
ভাড়া মালিকে
taken
মোক
the case?
ঘটনাৰ বিষয়ে জনায় আৰু মই নিজে ঘটনাৰ বিষয়ে
wearing mask.
অনুসন্ধান
Very much. But the thing is that, Lordship, what happened, one, the CCTV footage was there in the shop, Lordship. And from that, one vehicle's number is there, one truck, from where this stolen goods was put there. So after looking into the truck number, Lordship, it has been seen that it is one Samidul Islam. And he was arrested, owner, and he was arrested. And from that, another thing is came up, Lordship, from his mobile. It came to see that, Lordship, another person, that is the second petitioner, Lordship, Mohidul Islam. He was also got arrested because at the relevant point of time, when the theft was carrying out, Lordship, then this person was talking with this person.
So a link has came up, Lordship. And after that, with the help of these two accused persons, Lordship, this 28 lakhs, it is 35 lakhs, 28 lakhs of goods have been recovered, Lordship, from this house of the Sanidul, Lordship. And while interrogating them, another person's name came up, Lordship, Ansar Ali. They have all stated that he also involved. Apart from that, Lordship, another thing is also there. He's a habitual offender, Lordship. He was involved in 13 such cases, Lordship, and in which there are many cases. And all these persons are habitual offender, Lordship. They are doing this, there is a gang, Lordship, doing all these things. And another thing is also there, Lordship. There are other persons, 6 other persons are also there who are involved. So we have the 8 more days or 9 more days, Lordship, to investigate. So kindly at this stage, Lordship, it is not feasible to give bail, Lordship.
Lordship,
Because other persons are also involved, and moreover, recovery is also need to be done, Lordship.
Lordship, we don't know Sanidul Islam. Who is Sanidul Islam?
But CDR has been shown that they know not, Lordship.
Lordship, only 9 days left. Lordship.
But it is
We'll
sufficient to
cooperate with the
that
IO.
investigation, Lordship.
Lordship. Sufficient time
So I pray
have
before
got
your Lordship,
by
not
the
to-
IO.
Investigation is carrying on, going on, Lordship.
Also for the petitioner, the allegation against the present petitioner regarding theft of the large quantity of electronic goods from the shop of the superman, and the goods are valued at rupees 35 lakhs. The result of the city with sufficient incriminating material against the petitioner. There are learned counsel for the petitioner submit that much of the goods have been recovered and the petitioner therefore spent 31 days 9 hours. And there may be some mistakes of the present prisoners are habitual offenders and belong to a gang involved in such and despite passage of 81 days, it is sufficient time left to complete the investigations submit the charges. The considered view of court having regard to gravity of the offense material and capability of the petitioner. Not a fit case where they may be granted clarity the sense of text of it that particular prayer and vectors.
May I please, your Lordship? Lordship, in this case, the accused arrested on 8/8/2025, Lordship, and 85 days in the behind the bar, Lordship. And the allegation is 61-2 and 1031, Lordship, BNS, Lordship,
103.
103.
My lord, here, we have not received the PM report and SSN report, man. Document fix it Monday or Tuesday.
Lordship, today is the 85 days,
SSL
Lordship.
and PM report
My
not received this again on
Tuesday, my lord. Tuesday, my lord. Post, my lord.
Monday, yes, sir. Minute to get up. Huh? No.
May I please, your Lordship? My lord,
Did
he
you
has
receive-
been arrested on my lord.
Charge sheet submitted, my lord.
My lord, today is my lord 56 days, my lord.
Hmm?
Today is 56 days.
Charge sheet submitted. 7 for now. Wait.
Where is the
FIR, my lord, page, my lord,
Minor.
page 9.
My pleasure, Your Lordship. My lord, in this case, probably CD received, my lord. But due to some other difficulties, my lord, I am seeking on adjournment, my lord. Kindly next week, any date, my lord.
Next week.
Next
Fine.
week, any date, my lord.
Next
CD
Friday.
received.
CD received a prayer of learned counsel for the petitioner list the matter.
On 12th, my lord.
Must be. CD retained, my lord.
CD retained. Be retained.
Must be.
25.
Your Honor, CD have not received. 25 now.
No, CD not received, my lord.
It's
I'm
not
saying
received.
not-
Please again on
My lord, from Utalguri, my lord.
interim order passed earlier to confirm
21, my lord.
next date.
Must be.
27 and 28.
May it please, your lordship. My lord, if my lord may kindly take up 28 first, my lord, just for my convenience, my lord, since I have the notes there. CD was called for, my lord. The FIR is at page 19, my lord. If this is a case, my lord, before I really take my lord to the contents of the FIR, neither I am named in the FIR, nor there is any allegation so far as I am concerned, my lord. The FIR talks about a conspiracy wherein people have been possibly taken for work outside the state, and exploitation also has been alleged. So far as I am concerned, my lord, myself, when I had the small daughter, my elder child, my lord, 1.5 years old, I was looking for a house help to help me with my child management.
Your name is Priya Bansal.
Yes. And I had to my mother, my lord, I requested that I need a house help. And my aunt, my lord, who is the petitioner in the second case, she connected with an agency who provides
Yes, prosecution, what have you found against her?
What I have found, Lordship, it is in regard to this case, Lordship, one person, that is Meena, she is the main, it is also named in the FIR, Lordship. She is the main person, and she has many contacts with the agent in different places, Lordship. And she also has different houses in different places in India, Lordship. This Sanjay Dasrat, in this case of this person, Lordship, one girl was recovered. That is Samira Marak.
Samari Marak.
Lordship. It is also in the FIR. Two persons are there, Lordship. Suprina Marak, Samaria Marak, out of which one child was died, Lordship. And another, Samaria Marak, she recovered. She is of 14 years age, Lordship. And there, her mother is Monica Marak. And this Meena, she also sold this woman, Lordship, to another in Rajasthan and took 1 lakh rupees, Lordship. And what I have learned from this CD, Lordship, this one, Meena, sold this girl to Sanjay and then to Dasrat. And Dasrat was contacted with this Madhu. And Madhu then, she was need for household help, Lordship. And this was a niece of Priya. From Madhu, she has taken the girl, Priya, and she has given 30,000, and she has given it to the agent, Dasrat. So, as per this petitioner, I found only this lot. Otherwise, their statements are also there. I don't know whether their interim is there. Or,
No, 40-party notice was given to me. I
there-
submitted myself for interrogation. My interrogation has been recorded digitally. And that Samari Marak, which I am admitting, my lord, she was with me, and I handed over the girl to the police, and the police verified with the family members whether this is the girl you are looking for. They identified the girl, and now the girl is with the family members, my lord. My lord, my only thing that I am here before this honorable court, that girl was with me. That is the only thing, my lord. Otherwise, I'm nowhere connected. Even if the CD is placed, perhaps there will be nothing before me. And whatever I know about that agent, my lord, I have already forwarded. I only had the phone number, my lord, which I have forwarded to the police.
moreover,
And cooperated.
Moreover, one thing I need to that everything is there, Lordship, but the one of the most vital witness, that is the Samira Mara. Though she has recovered, I don't know, Lordship, why her statement is not there. It will be better clear, Lordship, although nothing is there, Lordship, but it will be better for the investigation that this Samira statement is not there, and Dev Dasrat's statement is also not there, Lordship. Otherwise,
But you were submitting something about payment being made
yes, there is
for
Lordship.
procuring the girl.
Lordship.
Does that extend to these petitioners? They also make payment to obtain the.
Yes, Lord.
My
They
lord,
have made payment to Sanjay. And this Meena, it is there in the
Sanjay
statement.
Meena, I
Sanjay-
don't even know them. My lord, so far as I paid fees, my lord, the agents, my lord, they take a service fees and they take the traveling cost. That is what I paid, my lord. It is not purchasing the girl.
But I looked into this statement of this girl, Lord. That is very vital. But I have not found.
And so far as the girl is concerned, in front of us only, she was inquired into like what was the situation, her condition. In front of me only, she was also inquired. The police may not have recorded that. I have got nothing to say. But because of this, my lord,
Let's
and
have the updated CD.
Not that may be.
my lord, it is the CD has been produced after the third or fourth round, my lord. And I have not placed for interim also in the beginning that let CD comes. Because even I am a responsible person, I am also a mother of two girl childs, my lord. And I'm aware of the protection that should be given. And this conspiracy, etc., my lord, we cannot encourage all this. But so far as I am concerned, I was just looking for a help with my little child who was in the hospital that time. And this summary happened to land up with me from through the agency, my lord. And she has not made any allegation. She was taken care of a child because she herself was a small child. My lord, at least this is a case where I should be granted bail, my lord. It's the discretion of the court. At least my custodial interrogation is not necessary. And I'm not even a resident of Karbi Anglong. I'm a resident of Delhi, my lord. I'm resident of Noida. And therefore, my lord, even if I'm granted bail, I will be cooperating with the police. And when I submitted myself, and the first day itself, when 41A notice was given, so there is at least no possibility of myself running away or escaping the interrogation. And that is how at least that much trust I must have built up to get a bail, my lord. And I leave it to my lords, my lord, because otherwise, whatever this conspiracy is, etc., this should be solved, my lord, because we cannot today.
We
If
were
we,
called.
my lord,
Both of you were called. Both of you appeared.
yes, both of us. We
That's-
appeared.
I think we need not, since they were called and statements were recorded,
Otherwise, I only want
having
to
this
say,
pending.
Lordship, otherwise, I want to state that, Lordship, otherwise, there is nothing I have found in the Sanjay statement also I have not found. But the thing is that it will be better. Otherwise, I have nothing to.
Better, of course, that they take their, but as far as
Lordship,
for
it is-
that reason we can't keep them.
we
in.
can't do anything, Lord. It is true, Lord.
We have to
Otherwise,
do
there
what
is nothing
available.
as such.
I have cooperated
Mm.
and I shall
Yeah.
continue to
Statement is also
cooperate,
there.
my lord.
That is also
So
there.
it's not a-
I'm great.
if we- then application. The- application, reflected in the FIR. Maybe 50. Which paragraph you have mentioned the allegation?
In paragraph 5, in paragraph 5, I have given the factual and
Paragraph 7.
and 6, 7, 8, and 9, I have given the complete fact, my lord.
Yes, for if there is a option. Material available there. Submitted by. The- appears that this under 41 as capital F here with if by the it appears with the I it has been located in state of having figures well as the fact that it is a cooperative it's the view that privilege of 3 8 same order in both cases.
I'm grateful.
May I please, Your Lordship? Here in this case, the allegation is that Lordship, certain amounts have been transferred to the account of
On
the.
the prayer in this, Lordship, we have received just now, Lordship, so we cannot go through, Lordship. Not in the morning hours, Lordship, we have not received it. On Monday, Lordship,
Let's have it on Tuesday. Monday
Lordship,
we have already fixed.
just now we have fixed it properly.
CD received it. Learn it. It takes for some time to go through the CD and take the matter of.
It is, Your Lordship.
My pleasure.
CD notice, man.
Here all the petitioners and informant are family member, Your Lordship, cousin, brother, parent and uncle. There is a dispute regarding the land correction, Your Lordship. In a village beside, Your Lordship. There is a brief possibility to set.
My lord, this is not the first, my lord.
Okay, when can you have it?
13th, one.
CD not received it again, not 13. 13, 11.
My lord. 13th.
Lordship, may I pray for a short date, Your Lordship, 13th?
It is a bit.
10 or 11.
What difference will one or two days? Don't haggle for like a
Oblige.
May I
My lord,
please?
here I have received the information that my lord 30 submitted, my lord.
Dated.
30 submitted.
My lord. I charge sheet number 115 of 2025, dated 31/10/25.
So
31 10. I see. Lordship, then I completed 73 days, Lordship, today. Entitled to get default payment.
The same appears before the question to minus for there.
Default bill, man. I'm paying for default bill.
after charge sheet has been
Yes.
submitted.
Yeah, Lordship. Even charge sheet submitted today, 73 days completed.
The statutory period is
60
what?
days.
60.
60 days. Half, Lordship. 303, 270.
Charge sheet date.
My lord, today 31/10, my lord.
Third learning council submitted. Submitted by learned. Charge sheet has been submitted by.
Charge sheet number 115 of 25, dated 31/10/25.
That is the 73rd day.
My lord, 72 days.
Yes, Lordship.
The period of the 60. The period that is submitted. deep usage.
Lordship, this is a quashing petition, my lord. I have received the affidavit in opposition. The matter actually, my lord, came into for filing of a quashing petition in terms of a settlement that happened between the same parties. So the amount has already been paid and the settlement has come through. But in the affidavit of opposition, my lord, they have now raised the statutory demand, which is according to them within that period, which was not paid. So according to them, that is also a part of it, and therefore they have objected for the quashing now. So I'm only requesting, my lord, if a 1 week's time can be given to me, I need to put a small reply. And accordingly, my lord, I'll serve them a copy can be heard, because they have now raised a claim which is beyond the settlement. Settlement is already done. We paid the entire 11 crores money.
So you were raising a press dispute after compromise
Yes.
settlement.
And they are saying that it relates to that period in which I was handling the affairs of the
That
company.
should also have been taken care of in
It has
compromise
actually.
settlement.
It has. In fact, in the agreement that has been mentioned, that is already there. However, they have raised the issue. I'm just seeking 1 week's time, my lord. Let me
Learned
reply to
counsel
this.
for the petitioner prays for a week's time to file a reply affidavit. Prayer is allowed, please again on.
My lord, I serve advance copy. May I request if it could be listed somewhere around 21st, if it's not inconvenience, my lord? It is a
21st
slight urgency in the matter.
November.
Extremely grateful. 21st. I'll serve them an adverse copy also.
For the respondent.
20th April.
Extremely grateful.
May I please, my lord? This is an appeal against conviction. In this present case, my lord, appellant has been convicted under section 326 of IPC by the learned court of additional session Judge Sonitpur. My lord, here the sentence that he was asked to undergo is 5 years, and along with that, my lord, a fine of rupees 50,000 has also been imposed. My lord, along with this appeal, my lord, I have also preferred a missed case because the present appellant is in jail. I request my lord to kindly first take up the missed case, my lord.
My lord, today is a Thursday, my lord, here, not is admitted, my lord.
No, my lord.
IA is for suspension of sentence, I think.
Yes, my
Notice
lord.
also not issued. Notice also not issued.
Notice to
No, no, LCR has been received by the court, my lord.
My lord. Notice the respondent, my lord. Today,
victim.
No, that is not mandatory, my lord. We have already taken step in this matter, my lord. So he may appear, my lord, if this
No,
honorable
is the
court,
service complete?
I think it should be completed, my lord, because we have taken steps.
No, you
But,
may have taken steps, not necessary.
But,
that service
my
is
lord,
complete.
we could not take the office note. But my lord, we listen that. Huh? Yes. My lord, so far as my knowledge goes, my lord, the previous time, the learned counsel for the victim and informant, they have appeared before this honorable court on the last occasion, if I am not making any mistake, my lord. We sure,
Last
no?
occasion, there is no order sheet as far as the IA is concerned. Let's see the main appeal.
My lord, basically, the sentence that has been imposed on this particular appellant, we are only 5 years, time. And there is every possibility in this matter, my lord, that the informant might file an affidavit that she has no grievance left upon the appellant, my lord. Because this is a family dispute, my lord. And where the conviction is for 5 years, my lord, here, my lord, the affidavit in opposition or any objection to be filed by the prosecution is not required.
This was issued on 5/9.
Yes, my lord. But we have taken steps, my lord. If they have any objection, my lord,
they could appear and they can place their objection at the time of final hearing, my lord. But miscase can be considered even in absence of informant, my lord. Because no substantial.
I think government's right to be heard is with regard to the main appeal only. With regard to suspension of sentence, is there any specific direction?
Here,
Although we do it as a matter of course.
my lord, what happened, my lord, in the appeal, my lord, first notice issued to the respondent if they appeared to pay any, my lord, objection or not. And in the meantime, when the record also came, then the I considered, sir. And but today here, my lord, trial for record received, my lord. But the informant victim, although whether notice served or not, my lord, that is also not.
Yeah, that is my query. Is
Right.
it necessary? On the main appeal, they will be
No, no,
heard.
if
We will not hear
suppose-
the appeal without hearing the informant. But as
Sup-
far as suspension of sentence is concerned,
My lord.
because it is a
After all, my lord,
question of
this is not a
liberty of the
case.
individual.
This is not a case of that gravity, my lord. My lord, whatever objection that needs to be raised by the informant, the same objection may be raised by the learned PP who is appearing in this matter. my
Yes.
lord. If he wants some time, my lord, I may accommodate him till next week. But to take these steps again and thereafter to wait for another 1 month is not feasible, my lord. And he was already in jail for 89 days, my lord. And he was suffering from severe liver cirrhosis, my lord. His condition is rapidly deteriorating. That is the reason why I request this honorable court to take up his missed case, my lord.
So it's 5 years only. We have been loving it. Okay, we'll dispose of this.
My lord.
Deeply obliged, my lord.
May it please your lordship. Lordship, by this application, lordship, the petitioners have sought for postment of, my lord, entire proceedings, my lord, registered under, my lord, section 7 and 13 of PC Act, my lord. But, my lord, there are 3 petitioners before your lordship. Petitioner number 1 is a, my lord, platoon commander of home guards, my lord. Petitioner number 2 and 3 are, my lord, volunteer home guards. What has happened, my lord? On 20 March 2018, my lord, complaint was lodged to the district commandant, my lord, alleging that the petitioner number 1 used to collect 2,000 to 10,000 per month from the Jawans, my lord, on the pretext of, my lord, providing placements. The FIR is at, my lord, page 23, my lord. My lord, along with the FIR, they have, my lord, the informant have annexed 2 money receipts, my lord, which are as page, my lord, 29 and, my lord, 27, my lord. These money receipts shows, my lord, collection of rupees 100 from the Jawans, my lord, under the letterhead of All Assam Trained Home Guard Association. Now, my lord, All Assam Home Guard Trained Association, my lord, is an NGO which is meant for the, my lord, purpose of providing financial assistance to the, my lord, family members of deceased Jawans, my lord. My lord, my lord, may kindly turn to page 56, my lord. My lord, this is the, my lord, general meeting of All Assam Trained Home Guard Association, my lord. The first para, my lord, may I read, my lord? Today on Sunday, the 19th of March 2017 at 11 a.m., a general meeting of the Kokrajhar District Committee of All Assam Trained Home Guard Association was held at the premises of Tulsibil Club under the chairmanship of the permanent president of the district committee, Sri Jiten Chandra Bormon. Following the agenda mentioned below, the following proposals were unanimously accepted by the meeting. Then it goes minus on and on. Now, my lord, may kindly turn to page 58, my lord. These are the rules and regulations which were framed, my lord, in the general meeting. Page 58, my lord, point 2, my lord. The rules and regulations are as follows.
To be eligible for financial assistance, the Home Guard Jawan must be a registered member by.
Finally today. My lord, are we hearing this finally?
No, but it has come from admission, my lord, admission column, my lord, my humble submission, my lord, whatever my learned is submitting, my lord. Can this court at least, my lord, adjudicate all these things, my lord?
My lord,
For that
what
purpose, my
I'm,
lord, please let me complete. For that purpose, my lord, I take your lordship to page number 42, my lord. Because this matter was investigated, day after circuit was submitted, my lord. Now it has been stated, my lord. Lordship, will kindly come to page number 42, my lord.
So what is the status of the trial? It is paid.
No, it
Yes,
is, my lord,
not
only,
state,
only,
my
my lord, only, my lord, someone was issued for their appearance, my lord. Thereafter, my lord, they have filed this division criminal petition, my
Then
lord.
we admit and fix it for hearing.
my lord, may
My
kindly
lord,
fix it
it
for
should-
hearing, my lord.
my
In
lord,
the
it is
meantime, my
an
lord.
early date, my lord. So matter has been state, my lord.
No, stay.
When? Heard, Mr.
Stay with it.
Sir,
Fine.
opted for the petition.
No. My lord, there is no stay. I'm humbly praying before this honorable court, my lord.
If we- Record is here, I think, TCR.
My lord, scan copy is there, my
Scan copy
lord.
has come, my lord.
Scan copy is there, my lord. Original record is still in the trial court, my lord. My lord, matter may be admitted and fixed for hearing, my lord.
Hearing. It's again. It's the matter for hearing on. If it did,
Last part of the double my lord.
My lord, till the next day, my lord, there may be
No, my
clearly an
lord,
interim
regarding
stay.
stay, my lord, I have objected.
My lord,
It is
I
a
have already,
certificate case, my lord, only, my lord, someone has been issued, my lord. Even, my lord, they can pay all their submission, my lord, at the time of framing of charges.
the purpose of fixing and date is that if we are to
my lord, my entire exercise will be futile, my lord, because
tell if
dates are already fixed there, my lord. I have taken 4-5 adjournments before the trial court, my lord. At least till the next date, my lord, because there is nothing on record which substantiates, my lord. There is
Come, my lord, after that,
where
lordship
is
may,
the
my
next,
lord.
when is the next date?
probably, my lord, December 1st week, my lord. I am not,
Then we are having it before that.
but still, my lord, at least till the next date, my lord.
My lord,
There
on
is the
25th,
next
my
date
lord.
is after the date we have fixed.
I'm deeply obliged.
But we have, as per the last order, we have taken steps. TCR may be. Any office there?
I'm appearing on behalf.
You have already appeared. The service is completed. Then for admission. Along with the TCI, it can be fixed for admission hearing. TCR has been received.
No, not TCR, but not called for next day.
Not called for.
Yeah, on next day, because if TCR is called for, because he has filed for interim.
No, scan copy of the TCR. Scan copy.
Interim maintenance.
Ms. Suensu, learned counsel has entered appearance to the respondent number 2. This is complete. Call for the scan copy of the TCR. Is the matter for not.
Yeah,
That
can-
they video.
no, the earlier than 17th of 18th, yes.
Deeply obliged.
May I pray, your lordship? This appeal has been filed under section 341 of the CRPC, lordship. As the honorable trial court below, the family court, has failed to entertain petition under section 340. The facts
Where
are
has
that
it
your
come up today?
lordship,
For orders, where has it come up today?
it is on page 19. Or it must not be on order time.
Huh? You were the legal aid counsel.
Yes, Lord.
So because you were absent on the previous day, it is listed today.
Lordship,
What is required to be done now?
Lordship, matter may be heard, Lord. I'm ready.
But it is here for orders, we are listed for application. What is your challenge otherwise?
Lordship, the facts are that while a divorce case was pending at court, Rohini court in Delhi, the husband respondent again filed a case in the family court, Kamrup Metro. And thereafter, knowing the facts, we filed a petition under section 340 in the court below. So on knowing that we have filed this petition, he withdrew his divorce petition. But
From Guwahati.
yeah, from Guwahati, not from there, Delhi. From Guwahati, he removed it, withdrawn, and Lordship thereafter only on the information he got from us, and but our petition under section 340 was not entertained by the court below. So for that reason, earlier also we filed a civil petition. It was by mistake filed civil petition. The Honorable Justice Surana at page 28 he observed that this should be a criminal petition under section 341. So for that reason, we are below this, before this honorable court.
Lordship, this criminal petition is not maintainable because it comes against the order of family court lordship, civil matter lordship, and lordship family court has says lordship appeal. That appeal would not lie against interlocutory order of the court because it is civil appeal lordship and it is come against the interlocutory order, not final. So this criminal petition is totally not maintainable, Lord.
I had already been before the Honorable High Court, and the order is on page 28 through civil revision petition. And also, despite receiving the notice, the respondent refused to appear before the Honorable Court. Thereafter, legal aid was provided to him.
His challenge before your lordship is FC civil case number order dated 4/1/23, FC civil number 1121 of 22, Erector A. Cannot be criminal procedure. And family court says appeal, section 19, says as provided in subsection 2 and notwithstanding anything contained in the Code of Civil Procedure 1986 or in Civil Criminal Code of Criminal Procedure 1973 or in any other law, an appeal shall lie from every judgment or order, not being an interlocutory order of the family court to court, what on fact and on law.
The lordship, the court below at least should have heard and the order should have been passed in the light of that. But even petition was neither heard and representation was not allowed.
This 340 petition is pending before family court at Guwahati.
Yes,
Where is that? You have annexed it.
yes, lordship. It is at page 20, lordship. I filed again petition that the matter is still pending after civil revision petition. The original petition is at page 12, lordship, and after civil revision petition, I again filed a petition to hear the long pending matter, but the honorable court refused.
What was the order in CRP 35 of 23? You stated that paragraph 6 of your application at page 21.
Yes, Lordship. Is paid at page 10. The initial order is there by the family court.
Here also section 340 of CRPC. Therefore, Honorable Court suggested him to come under section
Where is
340.
where is the order of the High Court?
At page 28, Lordship.
Page-
Operating
page
part,
28.
last page, 28, last page.
Para 6
Para 7 is relevant, Lord.
Para 6 kindly peruse. Kindly peruse para 6. Proceeding is not disposed of or is not no order for refusal by the learned trial court to entertain the proceeding under section 340 of CRPC. Therefore, Honorable Court directed him to come before CRPC. So with provision of section 341 CRPC. He has now come for civil procedure court.
No, I'm under section 341 only here.
If it's to go to section 340, it's to go to
I don't object for it.
Yes, but in this case, there is no order. 340 petition, is there any order?
340 petition, is
Where it
that
says
the
the
President has filed a
His appeal will lie against so and so
Has
against such
disposed.
order, but there is no order.
No order has been passed, neither it was entertained, Lordship. That is my grievance.
But he has filed a criminal case in civil matter lawsuit.
How is it a civil matter if it is a petition under 340 CRPC?
That mistake I already made, Lordship. I came before the Honorable Guwahati High Court under civil revision before.
He filed civil revision, High Court
Then-
says no civil revision. He files criminal revision, no, High Court will say no
There
criminal
was
revision.
no appeal lie.
Then where shall I go?
Section 90 says no appeal lie.
I'd learned it counsel for the petitioner. I'd learned it. You are you're appealing for?
The respondent, Vikas Agarwal.
This criminal revision has been preferred by the petitioner as he is aggrieved by the not disposal of a petition filed under section 340 CRPC, which has been annexed as annexure. You have not annexed it. That says that. Right. Yep, by the correct family code. In this regard, the petitioner had filed another application, which was the one that you just showed me, where this one. Right? Other app- For taking up the petition under section 346 here, which was filed by number 1182 stroke 0 21 and 20. But it submitted that no order has been passed on the state. By the it is that earlier approach is put by way of a civil revision under section 1156. But by order dated 14/12/2023, the High Court refused to accept the receipt under section 115 is as the same would not result in dismissal of the and dismiss the state application granting delivered the fit as rate of appropriate payment as made advice. So, when the it the as approach is put by way it third counted for the respondent not dispute the assertion of the petitioner that the petition under section 340 has not been disposed of by the certain prior current family. Considering this theory that the family court that dispose of the gift of the section before PCFD. It number double eight of 20. Right. Asking a period ordered that for. Yes, we have first directions to dispose of the application.
Obliged lordship.
Deeply
Obliged.
Yeah, please, Your Lordship. But in this matter, the notice was initially issued to the informant, my lord. It was issued on 5/3/25. Then we took steps, my lord. Then there's office note, my lord. He was not found in his residence, my lord. Out of station he was. Thereafter, my lord, on 25/7/25, we made a submission before the court, my lord. We'll take a paper publication, my lord, that notice. But I think there was wrong on our part. Because Lordship kindly peruse the order dated 25/7/25. That will take steps by paper publication. Actually, we ought to have told the honorable court, my lord. We fix a particular date so that the other side he knows and he can appear. And we could have taken with the registry. So through registry notice could have gone for paper publication. But there's a mistake on what I feel, my lord. So today what I submit, my lord. Since my lord, nowadays Lordship also allows that WhatsApp message and the email service, my lord, through PDF, my lord. If your lordship direct allow me, my lord, so I can take steps by that WhatsApp service and also email service, my lord. Beside this, my lord, once again I can take steps by registered post. First time he was out of station, let me have a chance for the second time. Suppose person to this steps, my lord, through WhatsApp and the email. If it doesn't come, my lord, then I think lordship will direct me or allow me to go for publication of newspaper. Because the submission we made to 25/7.
Which place?
It's in UP, my lord. It's in UP. Page number 3, lordship can see the address. Village Kant Dihesh, Post Office Bhujaini, District Sant Kabir Nagar, Uttar Pradesh. And he has given his email number also in page number 50, lordship you can find also. He has got email number, he has his WhatsApp number, all these things are there. Page number 50.
All right, we'll let you take that step, but we'll decide later on after you.
My lord, that's what. I will not make submission further, my lord, so that lordship can take up the matter. No, my lord.
Learned counsel for
Yes.
the petitioner, that he take steps by WhatsApp and email.
Email, my lord, yes.
Prayer is enough, however, the
And lordship may fix a date so that
question of completion of service by the applicant court will be decided subsequent. Is the matter again? How many? 2 weeks, 4 weeks?
I think 2 weeks will not solve the purpose. Let us make
January.
January. My lord. January.
It will be 8.
No, my lord. Lordship make it 3 weeks. Let us have a chance, my lord. 3 weeks. A particular date may be given. So that other side will know the date.
Even date after 3.
3 weeks, yes. Let me try, my lord, my luck this way. Oh, it's obliged, my lord.
Everywhere. The earlier occasion, your lordship, the criminal appeal was being admitted. But the I could not press the same for the paucity of time. So on the 7th occasion, your lordship, I could not press for the bail petition for the appellant. The lordship, the impugn order at page 28 of the criminal appeal, and 107 page is the relevant portion where he has been convicted.
We are on the IA now.
Yes, lordship.
What is the sentence?
The sentence is for 8 years for fixed period, your lordship. 8 years under section 304 part 2 IPC. The lordship will find at page 107 of the main criminal appeal the relevant portion.
in this case, Your Lordship, interestingly, there is a cross case, Your Lordship, where the judgment has been passed by the same trial court, where the appellant has been regarded as a victim. And Your Lordship will also find that at page 246 and the relevant portion at 290, where he has been compensated and has been regarded as a victim. And all the PWs of this particular instance appeal has been convicted in that particular case, Your Lordship. PW 1, 3, 4, 5, 6, 7, 8, 10, 13, all are being convicted in the cross case.
So in both cases, conviction.
Yes, in both cases, the conviction has been made. And the other case, the cross case, I have been regarded as a victim and I have been compensated. Your Lordship may find at the cross case at 246 page number. And 290 is the relevant page where the conviction has been made.
Judgment dated in cross case.
Twenty-five 2025 is the cross case that was being order was being passed.
Dated
25/07/2025 passed by the learned additional session judge FTC Achar.
in
In sessions case number 06/2013.
the judgment is available here.
Yes, Lordship. At page 46, judgment has been annexed herewith as annexure 37. And your Lordship will find the relevant portion at page 290.
It's in the IA or in the main appeal.
In the main appeal.
Main appeal page. the
In appeal
judgment-
page 246 is the cross judgment. And the relevant portion will receive at 290.
Anything on the merit of the.
Yes, Lord. Now, Lordship, in this case, initially the appellant was being charged under section 147, 323, 447 IPC. But later he was convicted under section 304 part 2 IPC. It means that he was not a part of the unlawful assembly, Your Lordship, nor he was any injury or trespass has been made by him.
So
And
was
without
there a
this
charge
info-
under 304 or not?
Now, Lordship, he has been directly convicted under 304 and without
Without
the
a charge.
without being charged. And he has been now, Your Lordship will find that the 4 exhibits A, B, C, D, which were the injury report of the appellant, which was being brought by the PWs of PW 11 and 17 during the trial, was not being considered while the conviction was being made. The rival contention was not being.
This is sessions case 307.
Yes, sir. During the trial, Your Lordship, 4 exhibits were brought into records by the PW 11 and PW 17, where he was also being heard. And those were not being discussed during the conviction when it was being made in the judgment, Your Lordship. Whereas the trial court is the same court.
The 302 charge was framed.
302 charge was being framed.
304 part 2 was not being charged. And Lordship, moreover, there,
302, if 302 is there, we can.
and
302.
while Lordship, when the appendix was being made by the trial court, which is available at page 112, Lordship will find that the exhibit A, B, C, D that was being brought into record by the PW 11 and 17 was not being made a part of the appendix. And therefore, it was also not being discussed while the conviction was being made. Moreover, Lordship,
What
I
are
would
those
like to.
documents?
Yes, Lordship.
What are those documents?
These documents were, Lordship, were the injury report of the this appellant, where he was being injured, along with the other co-appellants who in the other cases, he has filed a separate appeal.
Exhibit 1 to 11 is there. What is left out? Injury reports are at exhibit 5, 6, 7.
Yes, so the exhibit A, B, C, D that has been marked in the PW 11 and 17, that were not a part of the appendix that was being prepared by the court.
Exhibits
A, B, C, D. That were the injury report of the
they were
appellant.
exhibited by which PWs?
PW 11 and PW 17.
Not discussed.
Not at all discussed about it.
But they're not present in the appendix either.
Not also not present in the appendix. Apart from it, your lordship, the PWs, if we go through one of PW 1, 2, 3, 4, many discrepancies can be found. They are not the eyewitnesses, your lordship. They have simply gone through the trial court and given their witness, and they are being convicted also. The PW 1, PW 3, PW 4, 5, 6, 7, 8, 10, 13, all are being convicted in the cross case.
PWs?
PW 1, PW 3, PW 4, PW 5, PW 6, PW 7, PW 8, PW 10, and PW 13. They all are being convicted. Apart from it, your lordship, I would like to place the Bhagwan Ramasinde Gosai case, your lordship, where in the para 3, it has been said about the fixed period of sentence.
Yes.
Para 3, your lordship, may I read you. When a convicted person is sentenced to a fixed period of sentence, and when he files an appeal under any statutory right, suspension of sentence can be considered by the appellate court liberally unless there are exceptional circumstances. Of course, if there is any statutory restriction against the suspension of the sentence, it is a different matter. Similarly, when the sentence is a life imprisonment, the consideration for suspension of sentence could be of different approach. But if for any reason the sentence of a limited duration can be suspended, every endeavor should be made to dispose of the appeal on merit, more so when a motion for expeditious hearing of the appeal is made in such cases. Otherwise, the very valuable right of appeal would be an exercise in futility by efflux of time.
When the appellate court finds that due to practical reasons such appeals cannot be disposed of expeditiously, the appellate court must bestow special concern in the matter of suspending the sentence so as to make the appeal right, meaningful, and effective. Of course, the appellate court can impose similar condition when bail is being granted. Lordship, there is also a suo motu recent judgment being passed by the apex court based on the in this limited period sentence, and also another case, another being passed by the coordinate bench of the Honorable High Court. Based on the case of Bhagwan Ramatinde only, the coordinate bench of our court has passed. I would like to read the para 20 your lordship. In view of the judgment of the apex court cited by the learned counsel of the applicant, this court is of the considered opinion that the applicant has been convicted for a short term of sentence of 7 years, and at this stage, the contention raised by the applicant that he may get a favorable result in the connected criminal appeal may not be totally ruled out. Hence, this court is of the considered opinion that this is a fit case wherein the exercise of powers under section 430 of the BNSS, the execution of the sentence imposed on the petitioner may be suspended during the pendency of the connected criminal appeal, which the court here accordingly does. So therefore, pray before your lordship to kindly be allowed, the applicant may be allowed to go on bail, your lordship. Is there every merit in this case to acquit in the further hearing of this appeal?
Yes.
There has come, my lord, so my humble submission, my lord, at this stage, my lord, to consider the entire appeal, my lord, by fixing it. So since he is moving, my lord, this IA application, my lord. So may I take your lordship to page number 105, results, from memo patient. 105. So before that, my lord, start from page number 104, my lord.
Of the judgment.
Of the judgment, my lord, yes.
This paragraph.
Paragraph number 78, my lord.
Yes.
Lordship, may kindly, my lord, go to paragraph, the above paragraph 77, my lord. Significantly, there is no evidence regarding acting in cruel or unusual manner by the accused persons. However, he had guilty knowledge that such type of assault by a bamboo lathi over his head may result in death. It is noteworthy that the same bamboo lathi is easily available everywhere, and it is a blunt object. From the attending facts and circumstances, including the conduct of the accused persons, I am of the considered view that he is guilty under section 304, part 2 IPC. Although, my lord, the charge was under section 302, my lord, but the accused person, my lord, found guilty under section 304, part 2, my lord. Now, my lord, 78 paragraph, my lord. Now, coming back to the role and contribution of the other accused persons, let us reverse to the entire evidence on record. Section 149 IPC read that every member of unlawful assembly guilty of offence committed in prosecution of common object. The word unlawful assembly has been defined in section 141 IPC. After meticulous scrutiny of the legal aspect, I have found a common object to attract the family members of PW1. This is Sabir Ahmed by the accused persons. They have carried weapons like dao, lathi, etc. in their hands on the date of occurrence. There is no doubt in the prosecution evidence to the effect that the accused persons were carrying the seized objects like lathi, stone, etc. to attack and assault the victim family. The evidence led by PW 1, 2, 3, 4, 5, 6, 7, and 8 are found to be reliable and consistent to the effect that at the given point of time, the accused person, namely Sahabuddin, Torifuddin, my lord, is the respect petitioner, my lord. Now, my lord, they have mentioned the, my lord, learned trial court has mentioned the name of the, my lord, accused persons. Having lathi, rope, stone, etc., gathered at the spot in a violent mood and aggressively attacked the injured person, namely Sabir Ahmed, PW1, Abdul Quddus, now deceased, Mokbul Ahmed, PW7, Farooq Ahmed, PW8, Mamun Ahmed, PW13, Abdul Salam Borbia, PW5, and Noor Ahmed Borbia, PW6, wounded them seriously. The injured person sustained injuries on their body and they were immediately provided with medical treatment in the hospital. The medical officer medical examined all the injured person and proved the medical report in the court. During cross-examination, I find no substance to disbelieve his testimony. Rather, it supported the ocular evidence laid by the PWs. However, I am not oblivious of the testimony laid by PWC during his cross-examination that the road was full of snow. Now, my lord, there are clear evidence, my lord. On what basis, my lord, the accused person was convicted, my lord, and put after. Now, regarding my lord, since he is facing my lord with 18 applications, my lord, I take a lordship to my lord 2023 live law, Supreme Court 389, my lord. Om Prakash Sahani versus Joy Shankar Chaudhary. Two zero two three 2023 live law, Supreme Court 389. Om Prakash Sahani versus Joy Shankar Chaudhary, my lord. And only, my lord, the main question which was decided, my lord, in this case, my lord, the appellate court should not reappreciate the evidence at the stage of section 189 CRPC and try to pick up a few lacuna or loopholes here and there in the case of prosecution. Such would not be a correct approach. Therefore, my lord, another judgment, my lord, that, my lord, I'm just starting from the live law, my lord, 2025 live law, 2025 live law, Supreme Court 779. The parties' names are, my lord, Damna Lal versus State of Rajasthan and another. That was decided on 6/8/2025. My lord, in this case also, my lord, the High Court suspended the sentence, my lord, but Supreme Court, my lord, set aside the High Court, my lord, suspension order, my lord, considering the, my lord, Om Prakash Sahani case. Yeah. So, my lord, my humble submission, my lord, that since the LTR has come, my lord, the IA may be rejected at this stage, my lord, and then appeal may be heard at this stage.
Our Lordship, the submission that was being made, reliability on the PW witnesses, PW1, they are all being convicted by the same court. Now, how they can be so reliable? And the judgments that I have given, Your Lordship, is the judgment of the Honorable Apex Court of the 2025, based on the fixed term judgment, the conviction. So, my humble submission, Lordship, based on the Supreme Court order, he may be allowed to go on bail, Your Lordship. It's a fixed term judgment.
The Porua, the judgments that you have quoted today involve life.
Life law, Lordship, regarding the suspension of sentence.
What was the quantum of sentence in those cases? Was it life imprisonment?
So that's
Because there are specific judgments of the Supreme Court as cited by learned counsel as well as others,
my lord,
which we have been dealing with recently. They said in case of short sentences, fixed period sentences, bail should be the rule. Should be the rule. Yes, there are some exceptional circumstances. So things are different in case of life imprisonment, that extent.
My lord.
As far as the cases cited by you are concerned, what are the
I'm
sentences
only,
involved?
my lord, citing the principle, my lord, that at this stage of, my lord, considering 89 application, my lord, are there 89 CRPC, my lord? So what the High Court would do, my lord? High Court would not reappreciate the entire
That is
evidence.
correct. We cannot go to the depth of the evidence and pronounce that there is no evidence or anything of that.
Or, my lord,
That will
or, my lord,
influence the outcome of the appeal itself. We are only required to see if there is anything glaring or
here. That lordship will go through, my lord. Because from the judgment, my lord, it is there, my lord, there are
the learned court has not considered the evidence at all and went on to pass judgment. You can say it's a glaring omission. So there some kind of specific instances that we can go. We cannot discuss the merits of the evidence at length.
Merits of the evidence and, my lord, the pick up the, my lord, lacunas or loopholes. Instead of considering statement.
Otherwise, judgments cited that it Kiran Kumar is also there. Case of short-term judgments, given the state of our pendency, by the time the appeal is heard, the entire sentence may be served by the convict. That's one of the, anyway, with
Regarding the second case, my lord, Jamnalal, it is a case of POCSO, my lord. Case of POCSO.
yes, next.
The other case of 34 is a connected order process. That was earlier being allowed, you know, sir, to go on bail.
34.
34. It may be fixed for hearing together with this, out of the same FIR, out of
Yes.
same
34 is
Same
the
judgment.
hearing along with item number 35. Criminal revision 414 of 2024.
obligation.
Yes, 37 is appearing.
Maybe. I for coordination of delay of 200
Respondent has been served.
step has been already taken, but not written.
No office note. ID card in respect of the full respondent has not been received back as per office note dated 29/10/27. Which service is released again 2 weeks. Right. Item 35. It uploaded. Two minutes. It will look good. It will- 33, 34, 34, 35.
May I please your lordship? Lordship, in this case, the IA for bail, lordship, and the pushed conviction, lordship, under section 454 and 380 IPC, lordship. Lordship, please.
What is the quantum of sentence?
Yes, lordship, please.
Maximum one.
And the lordship, is 3, lordship.
6 months. Maximum.
1 year and 6 months, lordship. And a fine of the 5,000 fine. And thereafter,
1 year.
lordship,
1 year is the maximum one sentence.
rigorous imprisonment for 1 year, lordship.
So you are not granted bail by the trial.
Lord, Doctor, thereafter, the applicant lordship filed a revision petition, and the court passed an order, case lordship 10, in my IFR lordship. This- And he is in previous bail, but
In the earlier, I have found, madam.
yes, lordship. And this order not communicate in the trial court, lordship. Thereafter, the trial court warrant issued. Thereafter, he is again arrested and he is in jail, lordship. That is the problem, lordship.
I have found there, madam, that
Yes, lordship.
lordship passed order to remain on his previous bill.
Yes, lordship.
I found there in the IMI.
In
But-
this IA itself. In which IA?
There is, madam.
Yes,
The
lordship.
second- Second file. If you file, whole file. Move it. Why do you put it? I. Put it percentage. I lick. Eight double five. 8 double five.
I number 855/25.
I say record.
This one, order of
Kosami.
yes, 18/8/10/24.
Yes, sir.
In the meantime, petitioner is
My lord,
to
last
remain on previous bail.
Previous.
Then this was not communicated.
Not communicated.
As a result of which,
Warrant of arrest, lordship,
uh,
and he arrested and in jail.
had learned counsel for the petitioner. This IA has been preferred taking date for the applicant. Mumtaz Ali, alias Mumtaz Ali, who was convicted in page 9. It appears that by order dated 8/10/24, this court had allowed the petitioner to remain on previous date. Where it is submitted that the state, due to non-communication of the aforesaid order dated 8/10/2024, NBWA came to be against the petitioner, whereafter he was taken into custody. When were you taken?
Since 19/5/2025.
And has remained behind bars, having regard to the above is directed that the release of bail of with 20,000 security for like right. I this was the recording.
Obliged. Bad future lord. My lord, my lord, in this case, what had happened, if your lordship would kindly come to para 7 of the petition, my lord.
Yes.
Now 1, 2, 3, 4, 5, 6, 7. Line about 7 from top. Sentence starting with, after this said incident, one day the petitioner had suddenly received an SMS alert in his phone to the effect of crediting an amount of rupees 49,999 in his bank account. After having said incident, the petitioner immediately made a complaint before the concerned authority of the Canara Bank to toll-free number, and thereafter said bank account of the petitioner had been blocked on the basis of complaint submitted by the petitioner. No such amount has been withdrawn by the petitioner from his bank account number so and so. What had happened, my lord? An FIR was lodged. If your lordships will kindly come to page 15, the vernacular version. One Abdul Kalam is the informant. Page 15. এজাহাৰকাৰীৰ বিনীত নিবেদন এই যে মই উপৰোক্ত ঠিকানাৰ স্থায়ী বাসিন্দা যোৱা ইংৰাজী ইমান তাৰিখে ৰাতি 9 মান বজাত হঠাৎ মোৰ মোবাইল নাম্বাৰটো নং সিম কাৰ্ডখন বন্ধ হৈ যায়। যোৱা ইংৰাজী 4/4/25 তাৰিখে ৰাতি 9:45 মান বজাত মোৰ নামত থকা কানাড়া বেংকৰ একাউণ্ট নম্বৰৰ পৰা ইমান টকা ওলোৱা বুলি SMS আহিছিল। লগে লগে 1930 নম্বৰত অভিযোগ দিওঁ, কিন্তু কাৰ্যালয়ৰ সময় শেষ হোৱা বুলি কৈ মোক ৰাতিপুৱা 10 বজাত বেংকত যোগাযোগ কৰিবলৈ দিয়ে। পিছত যোৱা ইংৰাজী 5/4/25 তাৰিখে ৰাতিপুৱা বেংকত গৈ ষ্টেটমেণ্ট উলিয়াই দেখা পাওঁ যে মোৰ একাউণ্টত থকা 2,42,000 টকা নাইকিয়া হৈছে। লগতে 49,999 টকা হেলেমালি, দেট ইজ দি পেটিশনাৰ নামৰ অজ্ঞাত ব্যক্তি এজনৰ ইমান একাউণ্ট নম্বৰত ট্ৰান্সফাৰ হয়। So this is the allegation. But yes, money was deposited in my, credited in my account. I informed the bank in the toll-free number. Bank blocked my account.
That is the matter. Now, my lord, I do not know what this CD would reveal. And I have been arrested since 1st of September. Na? October, my lord, I am in detention.
How did you get so lucky?
But we have received the case diary, my lord. But what happened, my lord, the complainant, my lord, his SIM card, my lord, that was converted to eSIM, my lord, A20 SIM, my lord. And thereafter, my lord, this offense has been committed, my lord. Now, my lord, from my learned friend's submission, my lord, it is very much clear, my lord, what he has stated in paragraph 7, my lord. One day, the petitioner had received an unknown phone call from an unknown person who fraudulently introduced him to be an official of Canara Bank and sought the bank account of the petitioner. The petitioner on good faith shared his bank account with that state unidentified person. So nowadays, my lord, when anybody, my lord, if somebody asks, my lord, bank account, my lord, then a person gives share the bank account and in which, my lord, this amount has been credited. Here, everything, my lord, material has been collected by the IO, my lord, during investigation, my lord, and my lord, the amount has not yet recovered.
No, my lord, issue is not that. Issue is what investigation has revealed till date. My amount was credited in my account. I informed the bank blocked the account, and money is still lying in that account. So what is the question of no recovery? Lord, what is my role here? The investigation must reveal that. If you want to keep me under further detention, then you must show what is my role in this entire saga.
That is
Merely, my lord, some.
That is already in the case diary, my lord. I can place it before your doorstep also.
That's what.
As far as material is concerned, my lord,
There is material that you say there is against him. That mark that with what is it? Mark that.
Yes, sir. I have marked.
Possible, go through the case diary, my lord, pass an appropriate order. But prima facie, this is the fact, my lord. Because when my learned friend made the submission, it didn't appear to me that they have any material against me. They are just thinking, is it possible nowadays? Huh? And police has not even asked me also, but direct my decision.
Yes, everybody has got to be careful because from today
Yes,
we are
yes.
going live.
No, in fact, my lord, one day I shared my account number because I got a phone call that my mobile SIM card would be deactivated. Initially, I was told to pay only 1 rupee as a fee. Then when they asked for a OTP, then I realized something is wrong. Immediately, I called up the bank. It was stalled. Otherwise, it happens. Everybody is not that alert.
It happens to bank employees also.
Yes, yes.
To bank.
Diplo.
This is the second time, my lord.
None appears list after 2 weeks.
Lordship, the petitioner in this case is facing conviction in NI cases. Lordship. In the meantime, with the complainant, she has arrived at a settlement. So settlement amount was 13 lakhs 20,000. Lordship. As on today, she has paid 7 lakhs. Lordship. So recently, she has paid another 30,000. So after deducting all this, she is still required to pay 6 lakhs 20,000. Some more time may be given. Lordship. She is regularly paying, although she is having some financial crisis.
Lordship, the last payment was made on June, 12th June. And now, my lord, she have to pay me 6,000 rupees.
Lordship, recently she
Every
has.
day they are taking time, my lord. They have to argue against or make the payment, my lord. Issue or that day, my lord. They cannot take time on every
No,
date, my lord.
what will you gain if she goes to jail?
My lord, no other order than my lord.
Lordship, after the last date, she has made this payment. Lordship. I have got the bank acknowledgement.
What was the date of payment?
14/10
last
and
week.
14/10 and 30/10 yesterday.
So recently payment has been. Okay, let's wait. You wait. It will be better for you to wait for some time.
Lordship, only for a fixed date, my lord. That's all.
It is submitted that process of settlement is underway and it is has been making payment the respondent. And till now, an amount of rupees
7 lakhs.
7 lakhs has already been paid out of an amount of rupees
13 lakhs 20,000 is the
30
total.
lakhs, 30,000. The last of the amount was paid on 14/10/25 as agreed by the partners.
70.
Is the matter again on after 4 weeks.
Lordship, a fixed date, any date, my lord.
Okay, after 4 weeks.
Lordship.
Give a date of